in the appeal can Sienkiewicz Limited and Knowsley Metropolitan Borough Council against the order.
Yes, Mr. My Lord, just before we rose yesterday, I said I'd try and find out something more about the epidemiological studies, but I did try, but I failed, perhaps predictably. I'm sorry. Can I deal also with something else that arose just before we rose? The single fibre theory and its relationship with threshold. And Lord Roger asked me to, and I have prepared a note of what I said about percentages yesterday. Before passing it up, can I deal with it in this way? An important element of the medical evidence that underpinned McGee and Fairchild, and I deliberately refrain from using the phrase the single fibre theory. And that important element was that we don't know whether there is a threshold dose for mesothelioma, and we don't know what was the threshold dose in Mrs. Costello's case. In other words, we don't know whether in her case it was necessary for one to be operating at the time of the first genetic mutation, or two, or whether the same one or two might have operated at the time of the second genetic mutation. And so we don't know and can't identify what must have been or was in fact the contribution of any one or more fibres in the genesis of the disease. We don't know in the case of Mrs. Costello whether it was one fibre that did all the damage in the way that the insurers in Fairchild said that one fibre was capable of doing all the damage, or in the way that in Mrs. McGee's case it was possible that one siliceous particle opened up the skin and therefore rendered all the skin vulnerable to mesothelioma. And unless we know that, we can never say whether it is more likely than not, in the case of a chosen individual, that she would not have contracted the disease but for the designated exposure. Without knowing the size of the threshold, moreover, we can't say how likely it is that one of the defendant's fibres was in fact operative by being included within that threshold dose. And this is so even though we may know, and we never do, with absolute precision, what was the relative numerical contribution to the total fibre load. The point could be understood perhaps by reference to balls in a bag. Assume that instead of fibres, we have 1 million.
We have
small polystyrene.
1 million, did you say?
Yes, assume that we have 1 million small polystyrene balls in a bag. 85% are in the bag naturally, and they're the green balls. 15% are in the bag because of a breach of duty, the black balls. If a hole is made in the bag and the balls are ingested one by one, it can certainly be said with confidence that it's more likely than not that the first will be green and from an innocent source, but far less likely that the first 5 will all be green. In other words, the likelihood that all the balls ingested are green diminishes every time the threshold for causation increases. So if it's known that the threshold, for argument's sake, is 5 operative fibres, after a time, and depending on the relative contribution to the load of the innocent as opposed to the guilty fibres, there'll come a time very shortly when it's more likely than not that at least one of the causally contributed fibres comes from the defendant's source. If we knew that the threshold was 10, then in the proportions about which we're talking, it would be strongly probable that at least one black ball would be in there doing some damage, even though it might not be working alone, but perhaps working with the other fibres. That knowledge, in fact, if the doctors had the knowledge that there was such a threshold, would help claimants, because it would enable them to show that even at relatively low threshold levels, one of the defendant's fibre materially contributed to the causation of the disease, because it would be more likely than not that it had occupied one of the threshold dose. But we lack that knowledge. We don't know, because of the answers given by Dr. Rudd to Mr. Stewart, Queen's Counsel's questions, we don't know whether, and can't say whether it is more or less likely that it is a single fibre. That's why, or it may be why, in Australia they adopt a robust approach and say that in fact all contribute. I say all this lest anyone was to suggest that the state of ignorance about causation is something that benefits claimants unfairly against defendants. In fact, claimants would be in a better position if we knew that there was a threshold and where it is. It is uncertain. We will ever know what.
That might be true if one were only applying common law, but Parliament has stepped in a way which puts the claimant in the strongest possible position. Isn't that right? Wouldn't you say? In what circumstances can you conceive that a claimant is going to lose once a claimant can show exposure to any degree of asbestos in any one
well, the claimant can lose, and it's my next point, my lord, if the materiality threshold plays any part, and I'll revisit that topic if I may. But what I said just a moment ago may be, at least in part, an answer to my lord's concern, and it's this, that if we are to retain the doctrine that started in Bonington, that material contribution to causation of disease suffices for the purpose of establishing liability, then if there was, in an individual case of Mrs. Costello, there were 10 fibres working together, then the common law, since 50 years or more, will have said, well, as long as one of those operative fibres came from the defendant, then the claimant will recover. And what I'm saying is that the threshold for an actual contribution is going to be very low in the vast majority of cases, because if there are, for example, I will repeat the point, and I apologise for doing so, if we say that there are 5 operative fibres, you only need a relatively small percentage contribution from the defendant's fibres before it becomes more likely than not that one of them made up the threshold number. And so, for that reason, the position in which we find ourselves is one that is not unfair. Mr. Stewart, Queen's Counsel, in Fairchild, was very anxious not that Dr. Rudd should not resile from the concession, which became the bedrock for the decision in Fairchild, that he should not say that it was not as likely as not that it was one as several. The bed was, as it were, the evidential bed was made by that series of questions on behalf of the defendants in these cases. And until we move on with the medicine, we all have to lie in that bed.
That sounds like a jury point. The defendants defeated themselves by their own line of questioning.
But
It doesn't help us.
Well, Milady, perhaps it helps slightly more, because if perhaps different evidence on a different day, if someone had said, well, how likely is it that there is a high threshold, that's to say that you need 100 fibres working together, then we might be in a more informed position than we are today. But what I'm saying is that really until the medical evidence changes, then the best approach, and it is one that helps claimants in a difficult situation, is the Fairchild approach. So far as materiality is concerned, in response to a question from my Lord Brown yesterday, I was asked whether exposure to a single fibre was sufficient in causation terms. And the simple answer I gave was yes, although I think I also said afterwards that it was unlikely that a claimant so exposed would establish a breach of duty. A better answer, on reflection, I would say the correct answer, would have been to say that one fibre might be capable in a certain case of satisfying the causation test, provided the judge, the trial judge in the circumstances, considered it to be material. And there may be cases in which a single fibre may be regarded as material.
And what's it mean?
It would not be material, I would say, in the context of two massively exposed laggers. And so the answer to Lord Mance's question from yesterday, whether material increase in risk is an absolute or a relative concept, is that it must be a relative concept.
Or where do you draw the line? I mean, if it were by itself, you seem to be saying it would be material. If there are two massive other exposures, it's immaterial. Where's the line between a massive exposure and a material exposure? Is it hunch or
It's
common
not
sense?
hunch,
Or
it's judgment on the basis of the facts in the case.
I mean, that's if I may say so, that's not an answer. On what basis does one make the judgment would be the next question.
Yes. Well, what I would say is that any exposure that is not negligible has to be regarded as material.
What about any exposure which involves a breach of the employer's duty of care? Would that qualify?
It would, my lord, yes.
But is that by definition? Because you don't get a breach of the duty of care unless there's a foreseeable risk of injury.
No. The answer is that in these cases, one might have thought that there would be a limited number of factual circumstances in which those with this disease come before the court, but as we can see, there are many different ways in which they might. And the best way that this court can adopt, I would respectfully submit on authority and on principle, is to say that an increase in risk is sufficient, provided it is not negligible.
Well,
What does that mean in the light? Sorry.
No. Okay.
I've asked my question.
Yes.
But carry on.
I was just going to ask, you said it was a relative concept.
Yeah.
And supposing that you had a massive, people playing in the terrible picture, people playing in asbestos on one hand, but another one, which was an exposure, okay, and breach, but it only lasted for a week or something like one of the ones we've seen here, in these kinds of cases. In that situation, would the fact that there had been the massive exposure, let us assume from some company which was now bust and who couldn't be sued and so on. Would that affect, would you say, well, I mean, would that be a relevant factor?
Yes, it would be a relevant factor. Would it be a conclusive factor? Answer no.
In what way would it be relevant? I'm just trying to understand.
Yeah, no. Well, if one has the example, which one won't get in a case, but of 10 million against one, it would offend against common sense, it might be thought, to suggest that the one had materially increased the risk.
I mean, if Mrs. Willmore had gone on from school to work in a factory which had negligently exposed her to asbestos for 20 years, how would that have played in her case?
Depending on the evidence in the case, and assuming no problems with timing of onset, for example,
Yes, assume
then
all that.
assume all those things, then I would say that one, subject to the evidence, a judge might decide that it is negligible, or he might decide that it is not, depending on the level of exposure that was later found.
Well, then you can't really equate material with sufficient to constitute a breach of duty of care, because you can have two women side by side in the first week of their employment who are exposed to the same amount of asbestos. One then goes and lives in the Hebrides and is never exposed to any more than the ambient amount. And you would say, well, in her case, if she gets mesothelioma, this was plainly a material exposure. The other one is exposed to an enormous and continuous amount of asbestos in the course of her employment over the next 20 years. And you would say, well, it was quite immaterial in the first week of her work she was exposed to asbestos.
That, my lord, is the difficulty.
I mean, if one's got complete uncertainty about what is or is not material, on whom is the burden of proof that there's been material exposure?
Upon the claimant. But the more difficult question is for this court to try, or the more difficult task is for this court to try to proscribe in advance, in words other than those with which common lawyers are familiar, what in this particular area amounts to a material increase.
Well, your case must be materialist capable of having a causative effect.
Indeed.
And that's a quite different question from looking back with hindsight at a whole lifetime of employment and asking whether, on balance of probability, one reckons it did have a causative effect.
As a matter of, just going back to Lord Brown's point, the liability here would be strict, wouldn't it, in the sense that there wouldn't be a requirement of foreseeability of harm, because it's a Factories Act liability.
That's correct, my lord, yes.
Yes.
In this one, but not in...
Not in Mrs. Willmore's case.
No, not in Mills.
And can I just have one more? What's the factor of strict liability? I just wanted to check, and my understanding is correct. Liability was not strict under the Factories Act.
Well, when I say strict,
Yes.
in the sense that you've got to remove all harmful dust.
As far as we know.
And if you don't remove all harmful dust, then you're liable without foresight.
Yeah, so far as it has to be, so far as reasonably practicable. So if you have done everything you've...
It's not reasonably, it's practical.
so far as practicable.
Yes, but that doesn't involve foresight of the consequences.
It doesn't involve.
No. What about schools? I mean, presumably now there may be some different regime, may there? generally?
I think they're controlled by the 2008 regulations, but they were common.
There are as I can hear sotto voce being said, that the 2008 control of asbestos at work regulations may apply to schools. I don't know. I can't give a firm answer, but if one is needed, then I can.
But Mrs. Willmore wasn't at work.
No, she wasn't at work.
She was a pupil.
She was a pupil at school.
Yes, that's true.
But to give the complete answer to Lord Mance's question, the asbestos regulations came into force on the 1st of May 1970, and with their passing, liability became strict,
Yes.
effectively.
They're not at work. Not at work, actually.
It's not the 2006 regulations that came into force in 2008, we believe, are not limited to the workplace, my lady. So
Apply to non-domestic premises.
they apply to non-domestic premises, but perhaps I can pass this up in due course if it's thought helpful. Going back to the question of a claimant being required to assert on the balance of probabilities that but for the defendant's exposure, he or she would not have got mesothelioma. The question isn't, and this is set out in paragraph 9 of my case, is not and cannot be which is the more probable source of the fibres that cause the mesothelioma, because the answer to that is that we simply don't know. And I quote in paragraph 9 the part of the speech of Lord Reid from Bonington, and in particular the last 5 lines that begin, which was the most probable source of the respondent's disease. The dust from the pneumatic hammers or the dust from the swing grinders. It appears to me that the source of his disease was the dust from both sources, and the real question is whether the dust from the swing grinders materially contributed to the disease. The question is, in Mrs. Costello's case, she was exposed to a contaminated atmosphere, and the question is not which was the more probable source of her disease, the dust from the atmosphere or the dust from the workplace. Adopting Lord Reid's words, it appears we would submit that the source of her disease was the dust from both sources, and the real question is the Fairchild question.
But I thought the whole point of Bonington, I think we've been around this course before,
Yes.
was that it's a cumulative
It is,
case.
and that
But I mean, is it, I'm not quite clear, I mean, I thought we began this case on the supposition that this isn't, but are you saying it may be? I mean, is the science such that we don't know if it's a cumulative case or not, or how is it?
I do not suggest that this is a cumulative disease, and the science does not suggest that it is a cumulative disease. The reason why we look at Bonington is to see how things changed between Bonington and McGee, because Bonington, as my lord says quite rightly, was a cumulative disease, and just looking at the head note, it was said that every fibre inhaled had caused the total disease. But then we came to the Bonington, to the McGee situation, and that was not a, as could be shown, a cumulative disease.
But you do suggest that there may be a certain cumulative element by reference to your threshold possibility.
Yes.
And the truth is, it may operate in all sorts of ways. It may somewhat depend on odd things like, I suppose, the physical condition of the employee at the time of inhalation, and it may make a difference whether they're exhausted, whether they're sweating. We just don't know.
We don't. The point was addressed by Lord Roger in Fairchild when he said this is tab 7, page 189, that the Court of Session in McGee had lost sight of that important point.
Paragraph?
Yes, paragraph 129, my lord. It's in ward law. So what, respectfully, my Lord Roger was saying was that ward law was a convenient point of reference because it showed that a defendant would be liable 100%, as it were, even though the defendant might only have given a less than 50% number of fibres. All the claimant needed to do was prove that the dust from the swing hammers contributed materially to the dusty atmosphere. Now, Lord Phillips is plainly concerned about the effect of Fairchild in the sense that it sets the bar extremely low. But in our submission, the bar has been at that level since Bonington and Wardlaw. And the only extension of the bar being set at that height is that what is required is a proof of increase of risk rather than of contribution to injury. And the novelty of Fairchild and McGee was that a defendant was being held liable in a case where, if the single fibre theory was correct, it was possible that medically the fibre emanating from that defendant had played no part. And so the gripe, as it were, of insurers and defendants was to be, well, it may be that we did nothing, and so we shouldn't be liable. And that's how the single fibre theory came in. I've used those words.
You talked about the bar, but you've wisely not addressed the railings around the outside of the arena. But one is conscious that this is an enclave, and to some extent we're concerned with the railings in the sense that Barker suggests that they expand to cover, or is relied on, I think, by you as suggesting that they expand to cover competing clauses where one of them is ambient pollution. But the other aspect of the railing is really what you accepted yesterday, or asserted, namely that Fairchild's confined to single noxious agents. Is that a particular piece of the barrier that will stand pressure if someone leaned against it?
Yes. This is, of course, because
you're confident in your submission to that effect, but I mean, the next stage will be someone challenging that.
Medical causation.
Well, the next stage will be an attempt to extend this principle outside the present enclave.
This is without prejudice to your submissions in the next bladder cancer.
Exactly so.
Well, application or extensions have been attempted already, have they not?
Yes, they have, and some have failed. I mean, I've read the case of Transco and Griggs. I wasn't in it, but in that case, as as I read it, Milady in the Court of Appeal decided that Palmer Arch disease, about which very little was known.
Which case is it?
Transco and Griggs, it was a vibration to the hand case. And the threshold that might, on another day, have defeated the claimant in that case, but it didn't, as it so happens, was to prove on the balance of probability that the disease was vibration-related. And so that was the first obstacle or bar. And then, because of the uncertainty about dose, as it were, or extent of vibration, Milady in the Court of Appeal, Mr. Justice Wilson said, well, this does fall into the Fairchild exception because medical science can't help us on the strict causation of this vibration injury. So, coming back to what my Lord Mance said is, there is an obstacle or a potential obstacle in the face of asbestos claimants. And the real relative risk exercise that might be undertaken at some stage in the future and might restrict the number of claims that can be brought will be to say, well, how likely is it on the balance of probabilities that this disease was in fact caused by asbestos? But that's not the issue in this case. As for the bladder cancer case, the two competing causes in that case were tobacco smoke on the one hand and the aromatic amines from the first place, from
Chemical dyes.
Chemical dyes, yes, in the second place. And so what the claimant had to do was prove on the balance of probabilities that it was one causal agent rather than the other that caused the disease. And in our submission, this causal agency question, having its source before Bonington but reflected in Bonington, is not just a technical construct, but is something that has some meaning to the general population. Because if I would venture to suggest that if one were to go out into the street and say to someone, well, what caused Mrs. Costello's death, the answer would be, well, it was asbestos. And then the next question would be, well, what part did the defendants play in contributing to her disease? But if Mrs. Wilshire had gone in and she were in the street and someone asked her what had happened, then about to her child, then she would say, well, the child fell ill, and it could have been any number of things that caused it. We don't know. It could have been oxygen, it could have been hypercarbia, it could have been prematurity. And there's a very real distinction in our submission between cases that require the single causal agent in order to get into the, in order to come through the gates or over the railings and to the bar, which is the enclave, and those that don't.
Same for lung cancer, is it?
No. In lung cancer, my lord, the cause of the disease may be the inhalation of tar from tobacco smoke, or it may be the inhalation of asbestos fibres from the atmosphere. And in order to succeed, the claimant needs to show on the balance of probabilities that it was the latter, the asbestos fibres, rather than the inhalation of tobacco smoke that caused the problem.
Although they appear to work synergistically, in other words, if the risk of each by itself causing the disease is 100, if you have both types of exposure, then the risk moves up to 250 or even...
It does operate.
And I mean, the answer to your, it seems to me, that the appeal to the common person is that the common person might well say, not focus on what the cause was, but once told that there were two people, each of whom had broken a duty, and told, I don't know what the answer is because no one can tell me, but all I know is that I was exposed both by A and by B, both of whom were in breach of duty, whether it's allowing passive exposure to smoking or asbestos. A common sense person might say, well, they both ought to answer in the same way as Fairchild causes people to answer.
It's difficult because although one does spend a lot of time with a hypothetical common person, people would have different views, no doubt, and they'd express it differently. But some would say, we don't know whether it's smoking or asbestos. But perhaps the common person might echo what was said by the House of Lords in Wiltshire and say, but just because the defendant was in breach of duty doesn't make it any more likely that that was the cause of the disease. I would accept. So the claimant does have that threshold to cross. I don't need to retract that, do I?
As a matter of interest, I mean, you don't have to answer this question, but there has already been reference to insurers. Is this the type of exposure which is insured on the issue in the other case, the trigger case, is presumably whether it's insured under the old policies or under new policies? Was that the issue in that case?
In the trigger case?
Yes, I mean, that is an issue which is rumbling around.
It is rumbling
scenes,
around. What is said, there was one particular case, the Debates case, I think it was, but my learned friend Mr. Stuart Smith may be able to help more, in which an employer had bought insurance from an insurance company up until the 1980s, and the terms of the policy were that the insurer would indemnify the insured, provided the insured could show that the employee had contracted mesothelioma during the course of employment. After 1980, the wording changed, and to put it in a short version, the effect of it was that what the employer had bought was worthless, because until 1980, no one actually got the disease, but those who got it after 1980 were getting it because of prior exposure. So the judgment's a bit, yes. Now, the assertions in the appellant's case that Lord Bingham limited his decision in Fairchild to cases in which all 6 criteria were met, this is paragraph 14 of our case, has to be fairly qualified, we would say, by including reference to his lordship's expectation of incremental and analogical development over time. I think we are familiar with what Lord Bingham said at that stage. This is, we would say, barely a development of the Fairchild doctrine, but rather simply an illustration of how its principle applies. Lord Nichols' call for restraint, which the defendants pray in A, this is at tab 7, Authorities Bundle, page 159. Paragraph 43. what we say is that what Lord Nichols was there saying was, in the fourth line down, when he said that the principle applied is emphatically not intended to lead to relaxation whenever a plaintiff has difficulty, perhaps understandable difficulty, in discharging the burden of proof resting on him, is to avoid claimants' lawyers in cases that fall outside the enclave saying, well, we can't discharge the burden of proof, and so we'll use Fairchild. The difficulty that presented in Fairchild, and which Lord Nichols recognised did give rise to the exception, exists today just as it existed then. Lord Hoffman, at page 163, it's paragraphs 61 to 62, although it is right that he was talking then of a case in which there were multiple employers, it's also plain we would submit that he did not have in mind a single light exposure case, or if he did, he thought the claimant bound to succeed. That's paragraph 61 to 62.
It does look, looking at the language in which both Lord Nichols at paragraph 42 and Lord Hoffman at paragraph 61 express themselves. They talk about a significant exposure to asbestos, and Lord Nichols in 42 says, so long as it was not insignificant, each employer's wrongful exposure of its employee to asbestos dust and hence to the risk of contracting mesothelioma. That doesn't suggest that what they had in mind was a single fibre. It's difficult to describe it.
It is. It will depend on the circumstances of individual cases, and in a case where one had laggards working for 5 years for one defendant, 5 years for another, then a day walking past, well, may well make no significant contribution. But it is enshrined in the speech, that paragraph from the speech of Lord Nichols, and what is said by Lord Hoffman, that the test is insignificance. Can it be neglected, ignored? Is it negligible? Moving on to a point made in paragraph 15 of our case, the appellant suggests that in order to succeed in establishing causation, the claimant is required to prove that the exposure that put the defendant in breach of duty was capable alone of causing the disease. There are two answers to this. First, even if Mrs. Costello had inhaled no fibres from the general atmosphere, the absence of any threshold dose for getting mesothelioma means that it ought to be common ground or accepted that she may have inhaled a sufficient number from the defendant's factory environment physiologically to cause the disease. Second, as a matter of authority, according to Lord Reid in McGee, so it's tab 14, page 424. what Lord McGee says. Yes, it was held in the Court of Session. Yes, thank you. Page 4, paragraph B, down to paragraph G. I won't read it out, Lords. The important sense of it is that the words, he uses the precise words, the pursuer does not have to prove that the cause would of itself have been enough to cause the injury. It could be the case, we don't know, that the environmental exposure in this case was in fact insufficient to cause the disease, but that what tipped it over the threshold was the addition of the guilty fibres. Or perhaps the way in which the fibres were inhaled on a day-to-day basis in Ellesmere Court was insufficient to cause the disease. But that once they're inhaled with the intensity, the relative intensity that the judge found, then they did have that causal potential. We just don't know. The artificiality, as we would describe it, of separating out guilty fibres from innocent fibres had been highlighted, therefore, in Bonington and Nicholson and Fairchild, and exists no less here, where every day when she was not at work, Mrs. Costello was inhaling, it would seem, a small number of fibres. She inhaled many, many times more at work, and indeed those that she inhaled at work will have included some that had been brought in from the general atmosphere. Lord Roger said in Fairchild, paragraph 170, this is Authorities tab 7, page 207, and this is relied upon by the appellant, that, to quote the words before I get to them, that the defendant's conduct must have been capable of causing the claimant's injury.
I'm sorry, which paragraph, please?
It's page 207, and it's...
G.
Thank you, G.
The third.
These were the... this was Lord Rogers' enumeration of the various criteria. And this is the third. What we submit, Lord Roger was there intending, was to say that, I'll start again, I'm sorry. What I would say is that this needs to be read in context. The first point to make is that we do not know where the threshold is in a general or individual case. And we can never say that the level of exposure was in fact capable of causing the injury, only that it might have been. The sentence follows on, obviously, from the previous sentence, which says, secondly, part of the underlying rationale of the principle is that the defendant's wrongdoing has materially increased the risk that the claimant will suffer injury. It's therefore essential not just that the defendant's conduct created a material risk of injury to a class of persons, but that it actually created a material risk of injury to the claimant himself. And then, thirdly, it follows that the defendant's conduct must have been capable of causing the claimant's injury, One might have used underlining or bold for the claimants, just to show that we are talking about an individual claimant in this particular case. Or perhaps we need to show that asbestos is capable of causing the disease that this claimant got. It would be completely contrary to authority if it was suggested that it had to be capable alone of causing the disease, because we know that the concept of material contribution is so well enshrined. We don't understand how the suggested requirement that the exposure should have been capable of causing the injury, and this is paragraph 16 of our case for the reference. What the other side say is that that must carry with it the implication that it is reasonably likely that it may in fact have done so. It's right that terms such as material increase in risk are not always easy to redefine, but if the test is going to be that the exposure carries with it the implication that it is reasonably likely that it may in fact have caused the disease, then this is, we would suggest, a recipe for confusion.
Can I just ask a question about the prior assumption or finding on which this appeal is proceeding, namely that asbestos was the cause of the mesothelioma, because originally I understand that was an issue, and the judge seems to have glided over the issue, having heard evidence that if it could be shown that she was exposed occupationally at either Ogden's or with the defendants, then the exposure should be considered as being causative of mesothelioma. But this appears to be, I mean, reading some of the literature, a considerable number of cases which aren't or may well not be attributable to asbestos exposure at all. I mean, up to at most 30%, Peter would say, I notice. In the case of women, at most 33%, I think, or 30% in the case of women.
I think of the women, there were 110 whose cases were looked at. I think there were 68 who had a clear history of exposure.
Presumably, is it possible, I mean, it must be virtually impossible to distinguish between general ambient exposure and spontaneous mesothelioma without exposure to asbestos?
No. There may be one, it doesn't apply to those, but just to give the completely correct answer to my Lord's question, it has been suggested that in rare situations a child may contract mesothelioma before the age of 10.
Yeah.
But,
well,
but that would be a rare exception.
I mean, the amount of asbestos fibre found in the left lobe only was very small, and so, I mean, it didn't prove by itself asbestos.
It didn't prove it by itself. The right lobe was entirely encased in tumour, and so there would have been no...
but in a sense, one's putting the chicken before the egg. One's arguing that it must have been caused by asbestos because there was some occupational exposure to asbestos.
Well, the evidence that it was caused by asbestos was Dr. Lawrence's opinion. This is, I'll read it out because it's a short passage.
Well, it's the one in the judgment, is it?
It is the one in the judgment, yes.
Well, that's the passage I was looking at.
Yes,
actually.
yes. The judge said that Dr. Lawrence must have been talking of legal causation there. Yeah. But it wasn't seriously challenged at the court below that the medical cause of Mrs. Costello's mesothelioma was asbestos disease. And the whole exercise that we went through with Dr. Jones was comparing, on the one hand, her risk from occupational exposure, and on the other hand, her risk from environmental exposure. And the finding of the judge that isn't challenged is that it was caused by environmental exposure to asbestos. There was no evidence before the court.
I mean, it seems that's what seemed to me slightly puzzling, that the possibility of spontaneous suffering from mesothelioma not due to asbestos seems to have disappeared.
Well, and perhaps rightly so, I don't know, because this was a case in which, on any view, Mrs. Costello had been exposed to very significant quantities of asbestos in the workplace from time to time. And what is commonly said and was said here by the expert is that where you have a history of occupational exposure, it is reasonable to ascribe it to that occupational exposure, ergo asbestos.
The judge has found that not so, in a sense, if one takes his percentages or even your percentages.
He has found it not so, but he made a finding that it was in fact caused by asbestos.
Yes, I see.
To return perhaps yet again to Lord Phillips' question, it may be that on other occasions there will be a real challenge to the suggestion in a given case that the mesothelioma was or was not caused by asbestos. But that wasn't this case, and as it so happens, it wasn't Mrs. Willmore's case. Yes. And I think part C of the bundle, page 28, paragraphs 5 stop 6 and 5 stop 7 of the appellant's case, they don't argue against that finding. Can I then next look or invite my lords to look at the suggestion that when we have different exposures, slight exposures, we need to look at each separately and say, well, did it double the relative risk? We could imagine a situation in which the environmental risk was 10 in a million. For 5 years' employment by Mr. Smith, the claimant suffered exposure that created a 7 in a million chance. And so that, on the balance of probabilities or on the doubling of relative risk, that could not be found to have caused her disease. But what if, for the following 5 years, the claimant had been employed by Mr. Smith Limited, looking at Lord Hoffman's example, and had been similarly exposed, and suffered as a result of that second period of employment a further 7%, or a 7 in a million chance. Looking at the doubling of relative risk, 14 in a million come from employment, but only 7 from each individual employment. The claimant could show on the balance of probabilities using relative risk that it was during the course of employment that she got her disease. But if Malone and Friends' submission is correct, because we need to look at them separately, neither would be actionable. Which is illogical, we would say. What we would echo are the words of Lord Nichols when he said in Fairchild that, this is tab 7, page 157, that in order to be acceptable, the law must be coherent, it must be principled, and the basis on which one case or one type of case is distinguished from another should be transparent and capable of identification. When a decision departs from principles normally applied, the basis for doing so must be rational and justifiable if the decision is to avoid the reproach that hard cases make bad law. The principles that have been established since Bonington and then McGee and Fairchild are clear and are readily capable of being understood. There may be a small number of cases such as these, and the appellants suggest that there may be few, in which the court may feel that the claimant is getting a better deal than he or she should. But I would submit not. But if that is the case, then perhaps that is the price that has to be paid for coherence and internal consistency. The appellant argues that so-called ambient exposure should be left out of account and shouldn't be considered as a competing cause for the mesothelioma when considering whether Fairchild is engaged. In other words, Fairchild doesn't apply to single exposure cases. We deal with this at paragraph 17 of our case. This is, however, we would say, not only inconsistent with the principles that underpin Fairchild, but it is also inconsistent with its interpretation in Barker. In paragraph 18 of our case, we said that the answer given in Barker should suffice to dispose of, for the purpose of disposing of this appeal. And I would take the court to page to Barker in the authorities bundle, pages 35 to 36. The paragraphs are paragraphs 16 and 17.
Haven't you set it out in your case?
Sorry.
Isn't it in your case?
It is in my case, and it is, the passage is set out in my case. I'm sorry, I'm reading from a separate note. But what I would emphasise is that there is no logic, according to Lord Hoffman, in requiring that a non-tortious source of risk should have been created by someone who is also a tortfeasor. And then most importantly, the part that's in bold in our case and is on the top, at the very top of page 36 in the authorities bundle.
Mr. Melton, counsel helpfully apportioned time for argument on this appeal, and that apportionment gave Mr. Allen 3.5 hours. There are 3.5 hours left, I think, today. It seems to me you've probably made your points fairly clearly.
Thank you, my lord. What I'll do then, I've had the chance of speaking to my learned friend, and I suspect he will be less than 3.5 hours. But I'll turn to my left, if I'm ever forgiven, just to confirm that that's. A learned friend tells me he's more likely to be 2 hours, but nevertheless, I'm not going to use that to reassure the court. It's an invitation to continue for anything longer than about 20 minutes, if I may. So, taking things perhaps then slightly more briskly, Lord Walker, and I'll give the reference only, agreed with Lord Hoffman. This is at page 61. And Lord Scott also said, and this is in our case at paragraph 22, that it can make no logical difference what is the source of the potentially injurious agent. That's Lord Scott. I'll give the reference, tab 2, page 48, paragraph 59. Lord Roger dealt with the same point, my lord, at tab 2, my lord. Tab 2, page 60, paragraph 97.
I mean, you've all set this
Yes,
out
it's all, yes,
so
yes,
fully in your
Yes,
printed
it's all,
case.
yes.
I'm not wholly clear why we're going through it.
No, well, in that case, my lord, what I'll do is move on briefly then to consider this question. To what extent is asbestos in the atmosphere to be regarded as a natural presence there? We've seen in Margerison that there are episodes or periods of time when the asbestos in the atmosphere may result from a breach of duty, and indeed Pinder, the taking the material to the tip case.
Are there any statistics on this? Has anyone done any measurements over the years of the increase in asbestos in the atmosphere? Otherwise, it's all just speculation, as you put in paragraph 28. Plausible speculation.
Yes.
Of course.
We don't know. We know it's not naturally present in the atmosphere here, or wasn't until people started importing it.
What, here?
In the UK, yes. It's mined. It's not like pollens that are naturally present here. It's mined from South Africa, Canada and other places, and was brought over and used as the part of industrial processing.
Yes, that's it.
That was the point I meant to make. I then would draw attention to the cases of Abraham and Maguire and Brett and Reynolds, in which claimants have failed because they failed to establish a breach of duty. Can I move on to the question of materiality and de minimis then? I won't give again the numerous references to de minimis as being the opposite side of the material contribution coin. But what I would do briefly is go to illustrate from the speeches of Lord Bingham, Lord Hoffman and Lord Roger in Fairchild how it is legitimate to avoid a mechanical or mechanistic approach to causation. And perhaps I'll give the references for Lord Bingham. Lord Bingham, it's tab 7, page 134, paragraph 12. Lord Roger, it's tab 7, page 190, paragraph 132. But Lord Hoffman, I would take the Lords to his speech. It's page, behind tab 7, page 160. This is the speech and the concept to which my Lord Roger was referring yesterday. Paragraph 50. It's frequently said that causation is a question of fact or a matter of common sense. Both of these propositions are true, but they need to be analysed with some care in order to avoid confusion. First, in what sense is causation a question of fact? In order to describe something as a question of fact, it's necessary to be able to identify the question. And then going down to 52, the same is true of causation. The question of fact is whether the causal requirement which the law lays down for that particular liability has been satisfied. But those requirements exist by virtue of rules of law. And before one can answer the question of fact, one must first formulate the question. And the question that has to be formulated in terms of causation for the purposes of materiality is has the causation question a judge will ask at first instance is, well, am I satisfied that the claimant has proved a material increase in risk? And when asking myself at the end of the case, has that been established, I will consider whether, in my judgment, the contribution to risk was negligible. And then in paragraph 54, 3.5 lines down, Lord Hoffman said that one's never simply liable, one's always liable for something. And what we would say is that the touchstone for contribution, namely materiality, is informed by the setting of the duty. In a case where someone has been in breach of duty, and where a person has got the very disease that the creation of that duty was meant to create, and where it's known that only very small quantities of the toxic substance can cause the disease, is it reasonable to set a threshold which a claimant may never be able to attain, namely of establishing but for contribution or a doubling of relative risk? And the answer must be that it cannot. And although it may be an inexact tool, the concept of materiality, the obverse of being capable of being negligible, it is sufficient and appropriate. Finally, I should deal with two or three isolated and discrete points. The first is the question of the Compensation Act. The Act is behind tab 5. The Lords and my Lady were taken through the words of the subsections 1 and 2 yesterday. What we say is that this was Parliament's statutory assumption or declaration of the position at common law. Subparagraph A requires a claimant to establish exposure to asbestos. Paragraph B is the causation, the medical causation question. Paragraph C sets out the uncertainty, and the last half of paragraph D sets out the way in which the defendant may be liable because of the increase of risk. There is nothing more required in terms of establishing liability. And what we say is that this declares what we say is and was the common law position. I don't think anything I say about that can improve unless there are specific questions arising out of it. Next, in terms of whether there might have to be a retrial because we should have objected to the evidence of Dr. Jones going in, or whether we should have asked an adjournment. I did not, on instructions, ask for an adjournment or object to the evidence going in, because the exercise was, so far as I was concerned, going to be an illustrative one only. We did not seek an adjournment to get our own evidence because the case had already taken 5 days, spread over 2 months, and to open up the debate between two epidemiologists seemed to me at the time to be disproportionate and unnecessary for the reasons I've explained in detail today, and wouldn't have got anywhere. There seemed to be enough uncertainty within the expert evidence without the need to introduce yet more. In summary, there's no principal distinction between this case and that of Fairchild, and there can be no good reason, and could have been no good reason, in Mrs. Costello's case to ask her to achieve the impossible, namely to prove on the balance of probabilities that but for her occupational exposure, she would not have got mesothelioma. Unless there's anything else, my lord, then those are my submissions on behalf of the respondent, Mrs. Sienkiewicz.
Thank you.
You were going to give us a piece of
I
paper.
was. That was the other thing. Can I pass it up?
Mr. Pearce?
My lord, my lady, my lords, I follow.
Yes, Mr. Allen. Thank you. Mine begins at page 2.
I've only got
There
page
should be
1.
there should be 2 sheets for each of us, page 1 and page 2.
There shouldn't be 2.
What?
I'm so sorry if it's...
That's your submissions, maybe. I don't know. Is this it? I mean, it's page 1 and page 2. We should.
I've only got one page.
There should only be 1 page.
Well, in that
Beginning
case,
of the point can be demonstrated.
Yes.
well, I have something. I may have your submissions.
I'm so sorry. I'll
Nothing
show
rude written on the paper.
Not at all.
These two, I think, are
I'm very sorry.
This is all right.
Well, I don't have a sheet.
May it please your lordships, my lady. Much of the ground has been covered by my learned friend Mr. Melton, and my submissions will focus on 3 points. Firstly, the appellant's proposed threshold test, and in particular, the doubling of relative risk. Secondly, what's meant by material contribution in the context of Fairchild and mesothelioma. And thirdly, the judge's findings of fact in Willmore. Before addressing those 3 issues, can I say a few words about Fairchild and what has happened since Fairchild? Before the first instance decision in Fairchild, practitioners in this field assumed that the question of causation in mesothelioma was governed by McGee. The Defendant's Counsel in Fairchild subjected that assumption to rigorous analysis. Did in fact McGee provide the answer, particularly in the light of Lord Bridges' observations in Wiltshire? And of course the rest is history. And their lordships in Fairchild, having had regard to principle, authority and policy, determined that in respect of cases with the features of the 3 cases that were before their lordships, there should be a modified causal requirement. Each of the defendants before the court in the 3 Fairchild cases had exposed the claimant or deceased to asbestos in breach of duty. And the majority of those defendants were employers, not all, because the only remaining defendant in Fairchild was an occupier in breach of a statutory duty under the Factories Act, but it was said that that made no difference. In each of the 3 cases, there was at least one tortfeasor who had exposed the claimant or deceased to asbestos who was not before the court. Since the Fairchild decision in 2002, this modified rule of causation has applied in almost every mesothelioma claim. Other than Sienkiewicz and possibly the case of Jones and Metalbox, in all other mesothelioma cases, be they single exposure cases or multiple exposure cases, the modified rule has been applied. And it's been applied without creating undue difficulty for the courts. What Fairchild has not done is to extend the scope of the cases which succeed compared with the position before the first instance decision in Fairchild. So the cases that would have succeeded before Fairchild at first instance, those are the cases that are succeeding applying the modified rule. But of course, in Fairchild, the lordships have articulated the basis on which causation should be approached. Clarification as to the scope of the Fairchild principle has been provided by Barker. But other than perhaps with the exception of the Transco case to which reference has been made, in no other type of injury has the modified rule been applied. It has only been applied in mesothelioma cases. And this perhaps reflects, firstly, that it has been perfectly possible for the courts to apply the conventional causation rule for other types of injury or disease. And secondly, it reflects the particular difficulties that are posed by mesothelioma and the causation of mesothelioma. The appellants now submit that the law should modify the Fairchild exception and introduce a threshold test that has as an essential part of that test the doubling of the relative risk. And so the burden would be on a claimant to demonstrate a doubling of the risk, although, as it's put by my learned friend Mr. Stuart Smith, it wouldn't be critical if the doubling of the risk wasn't quite met. As we understand the submission, this threshold test will apply not just to single exposure cases, but will apply to multiple exposure cases, in that each tortfeasor, the court will have to be satisfied in respect of each tortfeasor that there has been a doubling of the risk.
I don't understand that position at all.
No.
That would completely destroy Fairchild.
Well, my understanding of the submission, and no doubt my learned friend Mr. Stuart Smith will correct me if I'm wrong, is that in the multi-exposure case, a claimant doesn't get a defendant into the Fairchild enclave unless the claimant can demonstrate the doubling of the risk against each defendant. If the claimant can do that, one then moves into the Fairchild enclave.
I'm sorry, the doubling of the risk by comparison to the by comparing the tortious exposure to the ambient exposure, is that it?
By comparing the tortious exposure of the individual defendant
yes,
to the ambient exposure.
Right.
Yes.
Well,
that is exactly what Mr.
That
Stuart
is-
Smith
yes.
argued.
Yes.
Yes.
Yes. But
So doubling of the risk was
there are two, as I understand it, two separate strands to the argument. One simply focuses on what is a material increase in risk, for which the test advanced is it's got to more than double ambient exposure before it's material. And the other is that as a matter of causation, in this case, it didn't do that. So it was not established that the exposure was a cause.
Yes, we accept that as the argument.
Two ways.
My Lord. Our submission is that the court is entitled to and should scrutinise with care whether such a proposed test has a firm evidential foundation. As far as we know, the only mesothelioma case in which this exercise has been attempted and the exercise being to look at a risk created by the ambient exposure and compare it with the risk created by the tortious exposure. The only case is Sienkiewicz. The use of the relative risk test begs the question, relative to what? In other words, what are you comparing the risk created by the tortious exposure, what are you comparing it with? In the Sienkiewicz case, my learned friend Mr. Melton has taken, your lordships, my lady, to the relevant evidence, where in that case, what the expert, Dr. Jones, was looking at, he was looking, what he did was to make certain assumptions about the levels of asbestos in the ambient atmosphere based on data from the United States and certain European cities, not in the UK. And from that data, he calculated an incidence of mesothelioma, and he did that by extrapolating from studies that were looking at much, much higher levels of exposure. So by looking at those studies with much higher levels of exposure and looking at the incidence of mesothelioma that was to be found, he extrapolated down to much, much lower levels. As we understand it, in the proposal that is made to the court as to what the test should be, that is not what is being proposed. What is being proposed is that the comparison should be between the tortious exposure and the incidence of mesothelioma, which is unrelated to specific exposure. And that is different from the exercise that was performed in Sienkiewicz, because the background risk would be looking not just at mesotheliomas caused by asbestos in the ambient air, it would cover mesotheliomas caused by asbestos that an individual could not recollect, and it would cover mesotheliomas unrelated to asbestos exposure. Now, if we've understood the appellant's position correctly, it does mean that they are proposing a threshold test that has not been undertaken in any mesothelioma claim that's come before the courts. And we ask rhetorically in that situation, what confidence can the court have in the validity of such a test? Now, my learned friend, Mr. Stuart Smith, says that the use of relative risk is conventional in the courts. Reference has been made to the Jones and Metal box case and to references in the judgment to what an expert in that case, Dr. Rudd, apparently said. But we haven't seen the reports of Dr. Rudd from that case. We've not seen evidence from Dr. Rudd, a transcript of evidence of Dr. Rudd. We see that's a very shaky basis to be trying to introduce a new test. Reference is also made to the Shortell case. Shortell case was a lung cancer case in which the deceased was a smoker. The important distinction between that situation and the present one is that in Shortell, the epidemiology established, first of all, the incidence of lung cancer in non-smokers. It established the incidence of lung cancer in smokers, and crucially, it identified a threshold for asbestos at which it doubled the risk of contracting lung cancer. And because of what has been already referred to as the synergistic or multiplicative effect of tobacco and asbestos, in other words, the combination of the two is not additive, it is multiplicative, essentially. Because of that effect, it doesn't actually matter how much smoking an individual has experienced, as long as that individual can demonstrate they have surpassed the threshold for asbestos exposure, they can demonstrate a doubling of the risk. And by that process, in a case with two different agents, smoking and asbestos, a claimant can establish on a balance of probabilities the likelihood that but for the asbestos exposure, he would not have contracted his lung cancer. We accept that that is a conventional approach. We do not accept that the court can conclude from the material before it that that approach is available to determine whether a mesothelioma should be attributed to an occupational exposure or an exposure, a specific exposure, rather than as a result of ambient exposure or unrelated to asbestos exposure. We just do not know whether the proposed background risk, as how it's referred to, whether that will be any sort of valid measure, whether it will be a valid measure for an individual living in Tyneside or an individual living in the Orkneys. We have no idea at all whether that is a valid approach. What is somewhat curious, given the stance that's adopted by the appellants, is this, that the judgment in Sienkiewicz was in November 2008. Mrs. Willmore's case was tried in July 2009. At no stage was it suggested that there was a burden on her to demonstrate a doubling of risk. On Tuesday, my learned friend Mr. Stuart Smith quite properly said that if a defendant wishes to take this point of doubling the risk, it's for the defendant to highlight it, to raise it. In Willmore, neither before the trial or at the trial, or even in the Court of Appeal, has it been suggested that the burden of causation on Mrs. Willmore was other than establishing the modified causal requirements laid down in Fairchild.
Mr. Allen, unless I misunderstand the position, the case sought to be made against you is a very simple one. It doesn't turn on doubling risk or anything else, but it turns simply on two things. First of all, that there was an agreement between counsel as to what would not be sufficient to constitute material increase of risk, one, and two, that but for findings of the judge which were impermissible, that agreement should have bit so as to defeat the claim, because, in essence, the agreement was that the claimant's evidence is not enough to get her home, and the appellant's case is the judge should not have accepted anything beyond the claimant's evidence, and impermissibly glossed the claimant's evidence by impermissible inferences of additional causes which were upheld by the Court of Appeal, and that we should hold the Court of Appeal should not have upheld those, and they should, as it were, be struck out. That, as I understand, is the case against you.
We do understand that,
yes,
my Lord.
A very simple case.
I will be dealing
yes.
with those matters in a moment. The point I was making was it's somewhat unfortunate in a situation where the appellants are contending for a new test, and where an expert is an expert in Willmore, Dr. Rudd. He's asked no questions at all relating to a doubling of the risk test, but reference is made to evidence he apparently gave in another case. Could I just complete my submissions in relation to the relative risk test, because I have almost finished those, if I might. The other part of the relative risk test, of course, is the assessment of the risk posed by the exposure. And 2 points. One is there are particular difficulties of assessing the risk at low levels of exposure, because the epidemiology hasn't been undertaken to demonstrate what those risks are. So one is dependent on extrapolating from studies that have looked at much higher levels of exposure. Reference was made by my learned friend, Mr. Stuart Smith, to assessments of exposure that were made by an expert in the Shortell case, Mr. Deary. And it is certainly true that in lung cancer cases, it is not uncommon for engineers to make assessments of an individual's total exposure. However, the court should be aware of the limitations of that exercise, and Mr. Deary, who is an expert who does often carry out this exercise, always has a standard form of words, which are these: extreme caution needs to be exercised in respect of asbestos dose calculations, as it is often the case that there is a paucity of evidence. So that exercise can be done of estimating exposure, and by a process of extrapolation from other studies, some sort of assessment of risk could be made in some cases. But, for example, if one takes Mrs. Willmore's case, there would be an immediate problem in her case of assessing the risk, because, of course, when it said that she was exposed, she was a child. And as far as we know, there is no epidemiology that has looked at the risk to children who are exposed to asbestos, and whether, in particular, a child has a vulnerability because of their youth. What we submit then in relation to the proposed test is that when one examines the evidential foundations for what is proposed, they are flimsy in the extreme.
I mean, if the evidential foundations existed, I mean, are you saying it's wrong in principle, or simply completely unworkable because you could never get the evidence to work?
It's unworkable. What I haven't repeated the difficulties that my learned friend Mr. Melton has flagged up, in particular by reference to the article by Professor Stapleton.
But have you? It hasn't. Mr. Stuart Smith actually adopted an approach which is perhaps less favourable than the one which you suggested he's arguing for logically. In other words, he's simply looked in the case below, or his client simply looked at the comparison between the ambient and the occupational exposure. What you objected to is that his test ought logically to be a comparison between exposure to mesothelioma, which is spontaneous and has nothing to do with ambient asbestos levels, and ambient exposure on the one hand, and occupational exposure on the other.
We don't accept that either exercise is valid.
No, but I mean, on the facts of Sienkiewicz, the exercise that was in fact conducted is less favourable than the other one would have been, because everybody accepts that there appear to be some cases of spontaneous mesothelioma which is not asbestos caused. So that if you added in those, you would get a relationship not of whatever it is, 10 to 4, or 24 to 4, whichever one takes, but take 10 to 4, one will get a relationship of, as a guess, 15 to 4, or something else.
It would be a more difficult hurdle for a claimant to overcome.
Yeah.
It would.
Well, no, it'd be it'd be a more difficult hurdle for a claimant to overcome, that's right. Yes.
It would.
So I'm getting very lost. I mean, they're not invoking this test in your case.
No.
We haven't got a statistic in the case. That's my
You're
lord.
simply assisting us with the general proposition before you get down to the nitty-gritty of your own case.
I am,
Yes.
my lords, and I won't take up any more time. But
But
this
you said one thing which interested me. It is possible in some cases to assess exposure to risk. You're attacking this particular case, but imagine the extreme case where somebody was employed for 2 weeks by employer A and for 20 years by employer B. In that situation, presumably the epidemiology would be sufficient to say the probable cause of this mesothelioma was exposure by employer B. The probable cause. You're not saying it's not possible it might have been attributed to the first 2 weeks. Is that not right?
I hesitate to agree with my lordship, bearing in mind the reservations which my learned friend Mr. Stuart Smith expressed about that situation.
Well, in which,
I'm sorry.
In what case then were you postulating that it's possible to assess exposure to risk?
I was saying that when one is looking at the effect of the occupational exposure, it would be possible in some situations to make an assessment of that risk.
Well, that's what I was putting to you. You have two different periods.
But
yes.
One has, in order to get a relative risk, one has to compare that risk from the occupational exposure with another risk, the background risk.
Well, I was asking you to forget about background risk and just think of two occupational exposures, which you say are circumstances where it is possible, in some circumstances, to assess the exposure. And I simply fail to understand how one can say one cannot, on balance of probability, at least in some extreme cases, identify employer B as being, on balance of probability, the employer whose tort caused the mesothelioma.
And on this topic, can I respond to something my Lord Phillips said yesterday when you asked a question about a relationship between dose and risk. And there is a statement within Dr. Rudd's evidence in the Willmore core bundle.
Yes.
At page 62. It's in the second paragraph where Dr. Rudd does say in the second sentence, however, the risk that mesothelioma will occur increases in proportion to the dose of asbestos received, and successive periods of exposure each augment the risk that mesothelioma will occur. And it's right to bring the court's attention to that statement.
That exactly reflects what Lord Bingham said.
Indeed, but it is subject to these qualifications. Firstly, fibre type. There is a vast difference in potency between different types of asbestos fibre. The usual figures given in respect of potency are that blue, that's chrysotolite, is 500 times as potent as chrysotile, and amosite, brown asbestos, is 100 times more potent than chrysotile. And so the court will appreciate that the different potencies of the different types of fibre can make a huge difference to the assessment of risk. And so it can't simply be an assessment of dose when fibre type is such an important factor.
Well, if your 20-year employer was also exposing the worker to the more potent fibre than the initial 4 weeks, a fortiori, one would be inclined to say, well, on balance of probability, it's the latter employer.
Well, if, to take your Lordship's example, if there was 4 weeks of chrysotile and 20 years of amosite or chrysotile, one would ignore the chrysotile. That's the reality. The risk posed by the chrysotile would be so small in comparison that it would be disregarded. The other two qualifications, one is the effect of time since exposure. This is the time cube point that's been mentioned. And the third qualification is the uncertainty regarding the threshold. Is there a threshold? If there is, at what level is it?
Well, can't one say on epidemiological evidence that if there is a threshold, it's pretty low?
Yes. One can say that no threshold has been identified, and one can say that asbestos has the capacity to cause mesothelioma at very low exposures. No minimum dose has been identified.
I mean, I can't think that Dr. Rudd, a meticulous expert, was meaning in direct proportion. I think he was using, I imagine he was using the expression loosely, wasn't he?
That may well be right, my Lord.
Well, Peto suggests, it's very difficult to digest all the statistics in Peto, and I haven't attempted to, but it does suggest that long periods of work introduce a much higher odds ratio in exposed industries. But one doesn't quite know why is the problem.
Yes, I'm very, very reluctant to go to the Peto report because one doesn't have the advantage of having expert advice on what should be derived from it. I too, my Lord, noticed, for example, looking at table 3.2.3 at page 951, that one didn't see in that table the odds ratio increasing as one would expect with years of exposure if there was a direct relationship between exposure and increasing risk.
I thought one did see. But anyway, there we are. That shows exactly the point you made a moment ago.
Yes. In the two cases, there hasn't been expert evidence that's looked at Peto and what one should understand from it. Could I just say very few words about the notion of the single exposure case? And we had made reference to the Margerison case that involved asbestos dust escaping from a factory. And my learned friend, Mr. Stuart Smith's response to Margerison was to say, well, that would have been an occurrence. That wouldn't, as I understand his submission, have been, assuming Mr. Margerison had also worked in a factory and been exposed, that wouldn't be a single exposure case. But it's a question of where does one draw the line, because although in the case of Margerison there were just two individuals, it will not surprise the court to hear that there were other cases of individuals living and working varying distances from the Roberts factory in Armley. And does one say, in respect of anybody living within a certain distance of an asbestos factory, that their exposure, therefore, is taken out of the norm for ambient exposure, and hence, if they've had some occupational exposure, they shouldn't be regarded as a single exposure case. It's unclear. And we say that it's illogical to treat so-called single exposure cases as different once one acknowledges that there is asbestos in the ambient atmosphere of greatly varying amounts, and that in certain instances it causes mesothelioma. And so the single exposure case in reality doesn't exist. I was going to make a few observations in respect of what is meant by material contribution to risk in the context of mesothelioma. And as my learned friend Mr. Melton has submitted, it is a relative concept. It has to be a relative concept because the same exposure, judged in terms of duration and exposure, the same exposure for one individual may be absolutely critical if they have no other history of asbestos exposure, compared with an individual with many years of, for example, working in a power station or in a shipyard with heavy exposure to asbestos, where the very same exposure is such a small proportion of the total that one would dismiss it. And our submission is that in judging what is material, no absolute standard can be laid down. And the submissions we make in relation to material contribution are very much rooted in the uncontroversial medical evidence before the court. And the two key points in that evidence are, firstly, that asbestos fibres can cause mesothelioma at very low levels of exposure, and that there is no minimum level that's been identified. And once one recognises those two statements of fact, it does become very difficult to determine a level in a quantitative way which is to be deemed material.
So I'm sorry, I'm just trying to follow what you're saying. I mean, it's really the same point as was asked, I think, to Mr. Melton earlier on by my Lord Chair. I mean, supposing you had, to take the example of somebody who's exposed, works in a factory, exposed for years on end, a lot of exposure. And then he goes to another factory where he only works for a week, but is to some extent exposed. But the first factory where he worked for ages, they're uninsured and so on. So he sues the second one. Now, do you say that in that situation, that would be counted as immaterial, even though had he never worked in the other factory, it would have been material?
Would your Lordship excuse me just a moment? if the expert evidence was that in that situation your lordship describes, in which the contribution to risk is overwhelmingly from one, it would be open to a court to hold that the other is not material. I can't gainsay that.
Or that it hasn't been demonstrated to be material.
That it hasn't been demonstrated. There is still uncertainty, and a court may conclude, as the court did conclude in the Cox case, because Cox had had many years of working in power stations and had a very limited period of employment with the defendant. The Court of Appeal upheld the judge's finding that that limited period of employment was still material. But what I can't say is, in the example that the Lord presents, that it would not be open to a court to find that the exposure for the short period was not material. A court could make that finding.
And how would it, on what basis, given that there would be evidence that, a single fibre, a cluster of fibres, and all these things, the same evidence, which was titled, people would say, well, after all, it could have been one fibre, we don't know, it could have been one fibre, it could have been one day, and the lifetime next door had actually not been there. On what basis would the judge hold that it was immaterial? Could positively hold that it was not to be regarded as material?
The basis that I envisage would be if it's, well, go to take the example looking at fibre type, if the limited period was to Christ time.
Oh, I mean, let me assume that they're the same type.
The expert evidence might be to the effect that the contribution to risk of one is so tiny in comparison to the contribution of the other that the court concludes it's de minimis.
And I suppose when you don't have the other, then it's like Sherlock Holmes is his much maligned story. You've got nothing else in the arena, so although on the face of it the risk of the exposure causing the injury is very slight, that's the one you light on.
I'm sorry, I'm not sure
So there are a number of illusions there. And not entirely safe illusions either, because the theory has been maligned. But if you have only one candidate for cause in the arena, then even though it's a very, very small risk on the face of it, you may be forced to accept that as the cause. Whereas if you have another, you have the same degree of very small risk from A, but you also have an enormous risk arising from 20 years' exposure to a heavily polluting construction firm as the alternative, then you're in a completely different situation, and whether it's judgment or common sense might enable a court to say, come on, this is the only cause that it makes sense to address.
We entirely agree, my lord, and that is consistent with the medical evidence provided by Dr. Rudd in the Willmore case. find, yes, it's in the Willmore core bundle at 61. It comes under his general comments in the first paragraph under the general comments, the last sentence, where Dr. Rudd states, when there is a history of past asbestos exposure, the balance of probabilities strongly favours that exposure as having been responsible for a mesothelioma which occurs subsequently. And we submit that this is an answer to the defendant's contention that there needs to be a doubling of the risk test, because this medical evidence, which we say isn't controversial, wasn't disputed in the Willmore case, says that if you do have evidence of exposure, given the potency for asbestos to cause mesothelioma, the balance of probabilities favours that as the cause.
But addressing the case you're not involved in Sienkiewicz, the judge has made a precisely opposite finding in relation to the particular level of exposure and the particular level of ambient exposure which he found out. So, is this a universal truth?
It is a generally accepted truth, and other than Sienkiewicz, I've never heard of a case in which it's been suggested where there's evidence of an actual exposure that in fact the cause was more likely to be the ambient exposure. Sienkiewicz is unique in that respect. At the beginning of the appellant's case, this is in the Willmore Core, in the introduction to the appellant's case, they draw attention to the debate in the United States. They say in the context of product liability, where the claimant argued for a test of any exposure while manufacturers...
Sorry, where are you reading from?
This is the appellant's case, my lord, at paragraph 1.2. In the Willmore Core, tab C.
Thank you.
And attention is drawn to a test in the United States of regular, frequent and proximate. And two cases are referred to. Footnote 2, one's Lerman and Pittsburgh, the other Borg-Warner and Flores. What's important to bear in mind is that both those cases were asbestosis cases. And asbestosis is a condition which usually requires many years of exposure. And where you have such a condition, it makes perfect sense to demand as a causal requirement that any defendant must have exposed the claimant to regular, frequent and proximate exposure. And that point is made in Lawman, which is at tab 25 in bundle 2 of the authorities.
I mean, do we have a simple statement of the American law on the mesothelioma cases?
I was going to take your lordship's related to Rutherford, which is not mesothelioma, it's lung cancer. But that was a very influential decision in Fairchild, referred to in 4 of the judgments in Fairchild, and does throw some light on the American approach to material contribution. Very briefly, I'm not going to read it out, but simply to draw the court's attention in Lawman at page 759. On that page, in the left-hand column, there's reference to section 431, so that's a rule, the law of Maryland. But on the right-hand column, the passage beginning, appellants would have as adopt a rule, and down to the end of that paragraph. And the court will see about 10 lines from the end. The court said this is a reasonable rule when one considers the Maryland law of substantial causation and the unusual nature of the asbestosis disease process, which can take years of exposure to produce the disease. Also when one considers the size and so on. So we submit that the nature of the condition is clearly important in determining the causal requirements that the law should impose. And the other case I mentioned, Rutherford, this is referred to in the appellant's case as an authority supporting their contentions for a threshold. And the reference in the Willmore core bundle is tab C, page 17 of the appellant's case, paragraph 3.30. The footnote on this page provides the references to the 4 judgments in Fairchild which referred to Rutherford. And Lord Hoffman described this case as a valuable and lucid judgment. My Lord Roger, at paragraph 161 of Fairchild, which I don't take you to, said of the judgment, it stands out as being directly in point and as providing powerful support for applying the principle in McGee to the circumstances of the present case. What we say is that when one looks at the passages that are quoted in paragraph 330, they do not support the proposition that appears above, namely that they're consistent with an imposition of a requirement that it's reasonably likely that the exposure has caused the injury. Because when one looks at those passages, in both they're referring to a risk of injury. Now, the Rutherford judgment, which is a judgment of the Supreme Court of California, it's to be found in volume 2 of the authorities at tab 27. It's a long judgment, which I'm not going to take the court through. But I draw the court's attention to the passage which begins on page 796
Can you give me the internal page reference? Because
Yeah.
mine has been printed upside down and wrong way round.
Yes, it's mine.
Not very helpful.
But if you give me the internal page reference, I expect I can find it.
Good. The lady at 957.
Thank you very much. That I can do.
And very briefly to explain, at trial it had been determined that the burden of proof shifted to the defendant to establish that their asbestos products hadn't caused injury. The Supreme Court held that that was wrong and unnecessary. And in this passage, beginning we conclude, the judgment of Justice Baxter summarises his approach, and in particular, 3 lines from the bottom. In general, however, no insuperable barriers prevent an asbestos-related cancer plaintiff from demonstrating that exposure to defendant's asbestos products was, in reasonable medical probability, a substantial factor in causing or contributing to his risk of developing cancer. And I won't read any more, but the
next sentence
is very much in point.
Yes.
And was relied on in Fairchild. The reason I draw the court's attention to this case, because there is some discussion of what is meant by a substantial factor. And in this case, a jury had determined that this defendant's contribution to total risk was 1.2%. And as far as one can determine, there was no attempt to upset that conclusion, that was still a substantial factor.
The Rutherford is of interest, isn't it? Because at 797, at the foot of section 1, they base that, rather as Barker did in this jurisdiction, on, it appears, proportionate damages.
That's quite right.
Yes, being awarded. Yeah.
That's right.
Is there any discussion on what is meant by a substantial factor?
There is, my lord. The reference, in particular, 815, the internal page. Sorry, the numbering is a little confusing. The right-hand corner numbering.
It's 976, 815 is internal page.
In fact, it should be 815B, internal page 978. And at the top of that page, second line, Justice Baxter states the substantial factor standard is a relatively broad one, requiring only that the contribution of the individual cause be more than negligible or theoretical. So that looks to be very close to the de minimis approach. There's an earlier reference, can I give the chord? At 808, internal page 969. And about 8 or 9 lines down, there is the sentence, the substantial factor standard, however, has been embraced as a clearer rule of causation, one which subsumes the but-for test while reaching beyond it to satisfactorily address other situations, such as those involving independent or concurrent causes. In fact, And then the next paragraph, the term substantial factor has not been judicially defined with specificity, and indeed it has been observed that it is neither possible nor desirable to reduce it to any lower terms. This court has suggested that a force which plays only an infinitesimal or theoretical part in bringing about injury, damage or loss is not a substantial factor. So,
808 at the bottom. Sorry, can I just be clear? I mean, the bit we looked at earlier that Lord Mansell drew our attention to, 797, end of second paragraph. I mean, does that leaves the matter as it was left in Barker here, pre-section 3?
It would appear to be so.
Sure.
Yes, this is, of course, is in the context of product liability.
Non-economic claims. Joint liability for non-economic. Portion of economic. David, no, to the bottom of the next page.
And then the final reference I was going to give the court was at 815F, where Justice Baxter, in the last paragraph, which begins in conclusion, does in that paragraph refer to a threshold. So this is internal page 982. But we would submit that the threshold that's described in that paragraph is the equivalent of the threshold we contend for of material contribution as we define it, rather than providing any support for the appellant's contention for a threshold.
Well, there are two things there. That, first of all, you must establish some threshold exposure, and further, in reasonable medical probability, that a particular exposure was a legal cause of his injury, i.e. a substantial factor in bringing about the injury. Are you saying that that's a test that's applicable under the Fairchild approach?
I think you have to read on, don't
Read
you?
on, yes.
You've got to go to the bottom of the page.
Yeah.
In order to show a substantial factor, you must show that was contributing to the risk of developing cancer.
Exactly.
So we say this is apt in the Fairchild context, and it does appear to have been quite an influential judgment when looking at the reference to it in Fairchild.
I mean, what you can't do is extract from this case the proposition that the actual causation of the mesothelioma has to be in itself a reasonable medical probability.
Yeah.
Correct.
Which Mr. Stewart may be seeking to invoke it for.
I was also going to draw the court's attention to the footnote on that page, which contains some differing examples of what was deemed a substantial cause. And it appears that what's termed the lenient approach is simply being at a place where there is asbestos without requiring any proof of exposure.
Is California out on a limb in this respect, as it is in rather a lot of others?
It certainly wasn't suggested in Fairchild, where this case was referred to in oral argument that California was out on a limb. And there was a good deal of consideration in Fairchild to cases from the United States. But other than that, I couldn't answer further, my lady. Could I come to the facts of Mrs. Willmore's case? As the court knows, in 1972, Mrs. Willmore, then aged 12, moved into a newly constructed school. The school, the construction of the school was not complete. There were various works of construction still ongoing, and some of the materials used in the construction of the school included asbestos materials in various parts of the building. It's accepted that insofar as those asbestos materials remained in situ, they did not present a risk of exposure. It was only if such materials were disturbed so as to generate fibres, dust, that they posed a risk to the pupils and the teaching staff. The learned judge, Mr. Justice Nichol, found that Diane Willmore had been exposed to asbestos dust in 3 different circumstances, each amounting to a breach of duty and each increasing materially her risk of mesothelioma. My learned friend, Mr. Melton, has already dealt with the connection between duty and the causal requirements, and it's no part of my submission that the causal requirements are determined by the duty in this situation. And an example will suffice. I think it was yesterday that my Lord Roger raised the question of innocent exposure before 1965. Was it always innocent? The answer is it depends on the level of exposure. If it was heavy, then there may well be liability. If it was light, there wouldn't be. But the standard of care judged pre-65 can't determine the causal requirements in a mesothelioma case. That the standard of care is determined by the appreciation of the risks of injury at the time, whereas the causal requirements are determined by what's known at the time of trial. What would we say be a rather strange state of affairs, though, is this, that the judgment of Mr. Justice Nichol dealt with breach of duty, and there is no criticism made of the way he dealt with that. And he found that, having regard to knowledge at the time, in the early 70s, the duty required of the defendant was to prevent exposure to pupils as far as was reasonably practicable. That was the duty in the 1970s. We say it would be a strange state of affairs if that was the duty in the 1970s, but the law decreed in 2010 that did not suffice. Simply exposure to asbestos dust did not suffice for satisfying the causal requirements. It might make sense if knowledge about the potency of asbestos determined that it was less potent than was thought in the 1970s. But of course, the reverse is true. It's regarded now as more potent, than in the 1970s. And yet the effect of the threshold that the appellants contend for would be that whilst the standard of care was based on preventing exposure, as far as reasonably practicable, based on what was known in the 1970s, the law would say that the causal requirement, that wasn't enough. There had to be more. And we submit that whilst the standard of care and the duty does not determine necessarily what the causal requirements are, the law has to have regard to the relationship between the two, and that relationship, we respectfully submit, would not make sense if the result contended for by the appellant was allowed.
Yes, we'll adjourn now until 2 o'clock.